A disturbing letter has been sent to one of you guys, my viewers, from TV licensing in response to a letter removing the implied right of access to their property. If you're wondering what that means, there is a common law right to come up to the door of your property, to knock on the door, ring the doorbell, if they have bona fide, genuine business with the occupier of that property. Even if they don't know you by name, there's a common law right, implied right of access to come up to your property. However, because it's a common law implied right of access, it can be removed. So it's not a statutory obligation, which you would not be able to remove unless it provided that you could do so in given circumstances. It is an implied right under common law, meaning it can be revoked. If revoked, then anyone has no right to access your property. They cannot come up to your front door, and it could well be amounting to harassment if they did do so after that on 2 occasions. So this viewer wrote to TV licensing, as many other people have done so, and as I've talked about in previous videos, this is a perfectly legitimate thing for you to do, to remove the implied right of access. They wrote to TV licensing to say 2 things. 1, I don't need a license, and secondly, I'm removing implied right of access. That's what they said. So this is the letter that TV licensing responded with. Now, I'm hoping to provide some sort of assurance here, but there is one bit of the letter that I do find concerning myself. I wouldn't be overly worried about it. I think it's either poorly worded or it's a veiled threat, but I do disagree with part of this letter. And just as a caveat, it goes without saying that I'm not encouraging anybody to break the law here, that is to watch or record live TV or use BBC iPlayer in contravention of the legislation to require a license. But that caveat out of the way, let's take a look at this letter. And of course, this is not legal advice. However, this letter response from TV licensing reads as follows. Thank you for your letter of date. I've redacted all the details, so this can't be traced back. Telling us that you do not need a TV license, which has been recorded under a reference number. Please use this number if you wish to contact us again. Now, there's no obligation to use that reference number if they wanted to contact them again, but obviously it would make it easier to do so if they did that, because then they'd be able to track back the previous correspondence. But there's no legal obligation to do so. There's also an element of data protection that comes up here, but there's going to be some legal basis for them to store certain information on their database in accordance with their upholding of the legislation. And again, we'll come back to that. I note that you stated you don't require a license and that you're withdrawing the common law right of access for us to visit the property. So acknowledgement of what's been said. You need, and then it goes on a bit of a generic spiel, warning, if you like, about what TV license is. You need to be covered by a TV license if you do any of the following: watch or record TV programs live on any channel, stream programs live, the keywords here being live, on any online TV service, download or watch BBC programs on BBC iPlayer. This is the only one where downloading something would require a license if it relates to iPlayer. Download or watch BBC programs on iPlayer. This otherwise applies to any device, including TV, computer, laptop, mobile phone, tablet, games console, digital box, DVD, VHS recorder. Now, this is a bit of a misnomer here, just as an aside. A DVD recorder, if the DVD recorder is not capable of TV, which most of them aren't, some of them are, I suppose. I don't know. I use an Xbox to watch DVDs, but so I don't know. Let me know in the comments if you've got a DVD player that allows you to watch TV somehow, but I don't really see how that's possible. The letter goes on. It may be helpful if I explain our policy on situations where a license isn't required. When we're told by a customer that a license isn't required at an address, we update our systems and stop contact for a maximum of 2 years. Seems reasonable for most cases because situations might change in 2 years. We may write again before that if someone tells us they need a license, fair enough, or if we believe the circumstances have changed. So, for example, this is another aside. If you buy a TV and there's a checkbox to notify and all that sort of stuff, you need to make sure that whoever you buy the TV from is not notifying TV licensing that you're buying a TV. I've known this happen before, and then TV licensing get in touch with them because they just think, hey, you bought a TV, you might be watching TV, and then they use it as an excuse to write to you again. That's poor play, in my view, on part of the company. But if you make it clear that you don't want them to do that, they would, the company that you buy the TV from would most likely be in breach of data protection if they did do so without your consent. TV licensing will visit some of these addresses, those addresses above, to check that a license isn't required. And again, there's no compulsion upon anybody to allow them in, unless, of course, there's a warrant. But I'll come back to that in a moment. As we're unable to confirm your status by visit, we reserve the right to use other methods available for detection of television receiving equipment. Now, as an aside on this television receiving equipment detection stuff, I've had a very interesting email from someone who, let's just say, had a very specialist intelligence role, and that's all I'll say, who confirmed that this is just not possible as a matter of science. And I'm looking forward to doing a very in-depth video, without revealing the identity, of course, as to why they say this is just not possible. These detection vans are just not possible. More on that later, so make sure you subscribe. The letter goes on. The unlicensed use of television can render a person liable to prosecution and a fine of up to £1,000. True, but the average fine is in the region of a few £100s. So you take your own risk, you take your own gamble if you do that. I'm not encouraging anybody to break the law here. The letter goes on. It would be helpful for us to have a record of your name to ensure that our database is accurate. If we write to the address in the future, we can confirm you're the occupier and the situation is still the same. No compulsion upon anybody to provide their name unless, of course, there's a warrant and so on, and then there's a duty to provide reasonable assistance, but I'll come back to that later. I'd be grateful if you confirm receipt of this letter, quoting the above reference and providing your full name. No obligation upon anybody to do that either, of course. I've updated our records as of the date that they received it to show that you wish to withdraw the common law right for TV licensing officers to visit your property. This next bit is good news, bad news. We won't visit you again unless we're advised by you that it's okay to do so. Great. Or, and this is the bit that I take issue with, or if you don't respond to future communications we send you regarding the withdrawal of implied right of access, that's a WIRA, at your address, or if we receive information to suggest you've moved from the address. The moving bit, a bit of an ambiguity, but the bit that I take issue with here is this bit here. If you don't respond to future communications. So are they now saying that if they write again and there's no response, which there's no legal requirement to respond to these letters, if they don't respond, they're going to turn up at the door in breach of the right to remove the implied right of access to the property? I take issue with that. And I believe that if they sent a letter and that was ignored and then turned up at the address 2 or 3 times, that might well amount to harassment, unless there's a very good reason for them to do so, such as they've notification that they bought a TV and all this sort of stuff, which may give certain reasons. But even then, they've removed the implied right of access. If they had any such evidence that they were watching or recording live TV or using BBC iPlayer in contravention of the legislation, they should be applying for a warrant. But to do that, they'll need evidence to do so, which they probably won't get. But I take issue with that part of this letter. The letter goes on. There's a chance that another inquiry letter has already been prepared for posting, which does not reflect what I've confirmed in this letter. If this arrives, I'd be grateful if you could ignore it. Perfectly polite and perfectly reasonable. Please contact us and quote your reference if you move to another address and wish to transfer this adjustment to your new address. That's also perfectly reasonable, because then what they're saying is if this person moves address and they wish to maintain this removed implied right of access status, that can be transferred using the same reference number. So that's fair enough. But as I say, that bit that I take issue with there is a veiled threat, or it's just badly worded, or if you want my real view, I think is plain wrong. They say, if you don't respond to future communications, they will turn up anyway. That's effectively what that seems to mean. And I do take issue with that, because that is not how this works. There is an implied right of access, and if that is removed, then there is no longer any right of access to that property. But as to the status of a warrant, If there is a warrant, then this changes things significantly, because if there is a warrant, then that is authority to visit the address. It is no longer simply an implied right. There is a warrant to visit the address, and I will attempt to bring on screen for you if I go back to here and remove this letter, or bring on this one. The powers to enforce TV licensing are under the Communications Act 2003, Section 366. So this sets out procedures and for issue and use of search warrants for the purpose of investigating offences under Section 363, which is the section that requires a license. So just note that subsection 771 here imposes a duty, so it's a positive duty on any person who is on the premises specified in the warrant, or who is in charge in the presence of a vehicle, etc., to provide any assistance necessary to enable any person acting under the warrant to examine and test any television receiver found there. So there is a positive duty to provide any assistance necessary. So this might see you falling foul of the compliance with a warrant if you do not provide any assistance. Whether that's prosecuted or not, whether that be wholly in the public interest to prosecute or not, depends entirely on the circumstances. Now, in this particular case of this writer, without giving away any details, there were various reasons why this would be quite difficult to comply with. And so any such arguments, whatever your arguments were, would be brought to court as to why you did not provide such assistance, even in the event of a warrant. But that would be an argument for which you would obviously have to seek legal advice. But this is a surprising letter, which I've not seen before. I've not seen this. This was obviously handcrafted rather than a straightforward, standard, bog standard, run-of-the-mill routine letter that's sent out en masse. This has been perhaps crafted for a specific response to these kind of letters. But let me know if you've been in that position before. Have you received one of these letters? Have you removed the implied right of access? Did you even know that the implied right of access existed and that you could remove it? Hopefully all that's of interest to you. If it is, please do consider smashing that like button and subscribe. That helps my channel grow. I would love to get to 1 million subscribers. That's my ultimate goal since I started this channel in lockdown. So I hope this has helped somebody. I gratefully receive emails where people have won their cases. They've found it easier because of my videos. I'm humbled, I'm grateful, and I thank you all so much for watching.